Good morning, I'm Gary DeWaal, and this is Bridging the Weeks for December 18, 2017 to January 5th, 2018, and today is January 8th, 2018. Happy New Year! Developments regarding cryptocurrencies continue to highlight legal and regulatory developments in the financial services industry at the end of 2017 and the beginning of 2018. The Commodity Futures Trading Commission issued a backgrounder providing its perspective on the self-certification by 3 exchanges of cash-settled derivative contracts based on Bitcoin on December 1st, 2017. Separately, a lawsuit that challenged the authority of the New York State Department of Financial Services to require so-called BIT licenses for persons engaged in a virtual currency business was dismissed, while the state of Texas issued a cease and desist order against a UK-based cryptocurrency issuing company in connection with various digital currency-based investment programs and a proposed initial coin offering. After an enjoyable one-week holiday in California in relatively balmy temperatures, I returned back to New York last week to very cold temperatures, including temperatures in the single digits this past weekend. Brrr! So I can quickly find some warmth somewhere. Let's get started. Last week, the CFTC issued a backgrounder generally summarizing its oversight and approach to futures contracts based on virtual currencies. Moreover, the Commission specifically reviewed the process that led to the self-certification by the Chicago Mercantile Exchange and the CBOE Futures Exchange of cash-settled Bitcoin futures contract and by the Cantor Exchange of a Bitcoin binary option contract on December 1st. Among other things, the CFTC noted that, in connection with the self-certification process, existing law does not authorize public input. Moreover, there are quote-unquote limited grounds for the CFTC to stop a self-certification, said the Commission. One such ground is that a DCM has filed a false statement. However, claimed the CFTC, quote, in the case of the CME and CFE self-certifications, no such grounds were evident, end of quote. However, the CFTC revealed that within the limits and parameters of the current self-certification process, the Commission staff has conducted a quote-unquote heightened review of Bitcoin futures contracts. This review included checking for derivative clearing organizations establishing substantially high initial and maintenance margin requirements for such instruments, exchanges implementing large trader reporting obligations at 5 Bitcoins or less, exchanges instituting information sharing agreements with Bitcoin spot markets so that they may access trade and trader data, and exchanges monitoring Bitcoin spot market data regarding price settlements and other prices to identify, quote, anomalies and disproportionate moves, end of quote, between Bitcoin futures contracts and the spot markets, among other measures. In addition, last week, the Texas State Securities Board issued an emergency cease and desist order against BitConnect, a UK-based cryptocurrency issuing company, in connection with various digital currency-related instrument programs and a proposed initial coin offering. Various related investment programs and a proposed initial coin offering. The Securities Board claimed that the investment programs were securities that were not registered with it as required, and that the firm engaged in fraud and made materially misleading statements in connection with the offer or sale of the securities. Also, during the prior few weeks, a challenge to New York's so-called BIT license requirements was dismissed by a New York court on the grounds that petitioner Theo Chino lacked standing to assert such an objection. Mr. Chino sued the New York Department of Financial Services in October 2015, claiming that, among other things, the DFS only had authority to regulate financial products and services, and that the oversight of virtual currency business activity fell outside this mandate. The court held that Mr. Chino abandoned his application process and failed to exhaust his administrative remedies prior to filing his litigation, and thus, quote, there is nothing for this court to review, end of quote. Yumin Lee settled a disciplinary action brought by the Chicago Mercantile Exchange for engaging in multiple round-turn transactions between an account of her employer, Tanius Technology LLC, and an account of a company formed by Miss Lee's mother, Carrot Capital Ltd., causing the Carrot account to profit and the Tanius account to sustain losses in an equivalent amount. The alleged trading occurred from March 17, 2015 through May 6, 2015, and was previously the subject of an enforcement action by the CFTC against Ms. Lee and Kering. To resolve the CME's disciplinary action, Ms. Lee agreed to serve a 6-year all CME group exchanges access prohibition as well as other penalties. And finally, Raymond James Financial Services Inc. agreed to be fined of $2 million to the Financial Industry Regulatory Authority for not maintaining an adequate system to review emails by its registered representatives. According to FINRA, the firm that relied on surveillance systems that automatically identified emails containing certain pre-programmed words did not choose words or phrases that would identify potentially problematic conduct in light of the nature of the firm's business and prior disciplinary action taken against firm employees. FINRA also claimed that the firm did not maintain adequate personnel and resources to monitor emails and unreasonably excluded certain firm personnel from monitoring, including persons in its headquarters office who service customer accounts in addition to other activities. Unrelatedly, JP Morgan Securities consented to a payment of $2.8 million to FINRA to resolve allegations that from March 2008 through June 2016, it failed on occasion to segregate customers' fully paid foreign and domestic securities in good control locations as required by law. This error occurred, claimed FINRA, because of, quote, design flaws and coding and data errors, end of quote, in its computer systems that calculated its possession or control obligations. The systems were apparently legacy systems of Bear Stearns Securities Corporation that JP Morgan acquired in March 2008. Well, that's it for this week's edition of Bridging the Weeks. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week. Until the next edition of Bridging the Week, stay warm and ciao.